Hello, am I audible? Hello?
Yes.
Yes. Okay, so welcome to day 3 of the summer school and good morning, everybody. I hope you all are doing well. So, today for the first session, we have Pragna ma'am with us. Pragna ma'am is the member of National Commission for Protection of Child Rights. Ma'am has also been an advocate in the Supreme Court of India. And today, ma'am is going to discuss about the role of UNRC, child rights in
Not audible.
Can you please unmute yourself?
Hello? Hello?
Ji.
Hi, can you hear me, everybody?
Yeah, we can hear you now.
Yeah, so
Yes.
I would want ma'am to begin with the session. Ma'am is the member of the National Commission for Protection of Child Rights. And today ma'am is going to discuss about the UNRC, child rights in conflict with law, child care and protection, child care and its challenges and good practices. So ma'am, I request you to begin the session.
Is it possible that you can enable share screen?
Yeah, moment.
Ma'am, you can share screen now.
Wait. Just a second. Just a second.
Good morning, all. Thank you so much for inviting me. And now, she already mentioned about the 4 points we are going to discuss in next 30 minutes. So, UNCRC and definition of child. Uh, we all know that United Nations Convention on the Rights of the Child adopted in 1989. Total 54 articles are there, of which 41 refer to substantive issues. So it was ratified by all countries except USA. And in 1924, League of Nations adopted Declaration of the Rights of the Child. And 1948, it was Universal Declaration of Human Rights. 1959, Declaration of the Rights of the Child containing 10 principles. In 1979, 20th anniversary of the declaration, as a child, I know we celebrated like anything. In all local languages, regional languages, the entire world we celebrated. So at this time also, uh, first time the child rights issue came forward, and India also adopted next year. So when UNCRC defines who is a child, so there is a lot of differences in other nations also, and even UNCRC, slight contradictory thing is there. So let us discuss about that. UNCRC defines a child to mean any person who is below the age of 18 years, unless under the law applicable to the child. Majority is attained earlier, however, allows for children above 15 years to participate in armed conflict. It's not allowing directly. If we go through the this thing articles of UNCRC, above 15, below 15 years is punishable. So slight contradictory. Even in Indian laws also, different laws are there to protect children, and age, particularly age, is there is a lot of difference. Various countries define child differently. For example, Singapore, a child is someone under the age of 14. In Iran, It's a 9 lunar years. We know because all you students, you are well connected with the internet and all. So 9 years is very early, and 15 lunar years for boys. Pakistan 16 years, and we know India it's 18 years of age according to JJ Act, 0 to 18 years. Boys and girls, they are all called child. Two categories of children as provided UNCRC. What are the two categories? Children in conflict with law and children in contact with law according to UNCRC. According to Juvenile Justice Act, it changed into CNCP, children in need of care and protection. This is slight difference, but definitions are almost similar. So entire nations, they define differently, but basically we can consider that majority of countries, they consider 0 to 18 years, just like India, as children. Some variations are there, some amendments are going on, but basically what is the definition of child? Child is, we all know that after 2012 post Nirbhaya, here also rape laws were amended, and above 16 to 18 years, though 0 to 18 years we treat as child, but 16 to 18 years, if they commit heinous crime, they are going to be under the law, the punishment will be, and the entire procedure, they are going to treat it as adult, but by children courts. So there is a difference, even though a lot of contradictions are there, even though law amended, but the procedure will be same. So basically 0 to 18 years are considered as children. So this is the definition part, and now data is available everywhere. Child protection data is there. So 2 billion plus child population under 18 years and 25.7% total world population. So almost 1/4 population is below 18 years. And these juveniles in India, 31 plus. So the one observation is there, 99.3% juveniles were boys who are committing crime. So when we collect data and research, we conduct researches, I am happy that this organization, ISLR, and all interns over there, and this is summer internship, I think, summer camp. So you should, people like you, youngsters, you should focus on this type. Organizations like us, NCPC and state commissions are there, and ministries are there in our country. And in different parts of our world, they are conducting. But societies are different, and data is different, and research should be, comparative study should be there. So these other details are visible over there. More than 3 lakhs childcare institutions. They are institutionalized children. Now, entire world, they are looking for deinstitutionalization. Let us discuss about what is institutionalization, why deinstitutionalization is needed. But the third point is, now if we want to focus on elaborately, what exactly children in conflict with law? According to our system in our country, already I told, below 18 years, any child who is below the age of 18 years and in contact with the criminal justice system, as he or she is alleged or found to have committed an offense. If it is an allegation or if proof is there, or they are under trials, they are all called as a children in conflict with law. The age of criminal responsibility may differ in different countries, but they are considered as a CCL, the term used, children in conflict with law. So This is a repetition. India, it's like that, 93.9%. Rights of children in conflict with law. So though they committed some petty or heinous offense, but they are having different rights. One of the foremost right is right to fair trial. We know there should not be any discrimination, or fair trial is a right for every human being, and child is protected by some more facilitated by some more child-friendly courts and all. In the next slide, it's there. Right to equality, right to legal representation, and elements for protection of child in conflict with law. Prevention, diversion, reintegration. These 3 points we are going to discuss now. Prevention seeks to ensure that children do not come in conflict with law in first place. How? Why? What are the reasons? How can we prevent? General and specific preventions. So reasons why. We know that. What are the reasons? Basically, why a child, check this audio. Child is in conflict with law. Foremost reason is poverty, but data shows differently. Even without poverty, educated people, their children, juveniles, they are committing crime. But basically, children who are entering into this type of system, foremost reason is poverty. Second, lack of education, lack of health facilities, lack of family, lack of shelter, and most importantly, peer pressure. So general prevention, how can we prevent that children, they should not become CCL, conflict with law. Free education for all children, financial assistance to families, employment opportunities, affordable and adequate housing, counseling and etc. in schools and other institutions also outside schools. Specific prevention, identify the vulnerable children through survey, data collection, reporting, and provide assistance to children. These I came to know about Yuva and all in Delhi police. They are doing from almost 2 decades. But what is the output? Is even these type of experimental special prevention, they should be updated according to the need of the day. So then diversion seeks to ensure that the children in conflict with law are diverted from reoffending while safeguarding their rights and providing a child-friendly justice system. In India, it was declared that every district should have a child-friendly court, at least a child-friendly corner, and every police station should have a child-friendly corner, just like a desk for women. And every district should be now the enactment is there, and the provisions are there, acts are there. So this special juvenile police unit for every district, but it's not mandatory. The duties are defined, but the stakeholders, they are not, according to me, it's still a lot should be done. So how we can application other than government agencies and other stakeholders, how can we go ahead? So research the existing system and the beneficiaries, collect data and analyze this same to identify the needs. Use of alternative institutions and measures instead of courts for adjudication of cases. Ensure sensitization of police officials and child-friendly apprehending protocol. This is what I told in the beginning. Use of alternative sentencing options. Child-friendly custodial measures. The main aim of justice delivery system should be restoration and rehabilitation, not retribution. Restoration and rehabilitation, it's there in our JJ Act. But at the time of implementation, in my 1.5 years as a member NCPCR, on High Court direction, we send every month, even once or twice I personally visited Tihar jail, the jail number 5. where under trials are kept. 30 to 50 approximately, in between this number. Every month we are after inspection we'll find out that they are minors below 18 years old. Some kids, they want to avoid this social stigma and all. They'll just enter their age as above 18 years in petty crimes also. They are in Tihar jail along with other accused. So this is the situation of our own in our own country. So we can imagine about other countries, underdeveloped countries, and other system. Though more than 5 or 6 departments are there to take care of these children, they are not supposed to enter into adult jails. They are having observation homes. The entire system is there. Even though I found that this number, this much, in only one jail. So this is my last 1.5 years in experience. More than 600, I think, juveniles we identified. So next slide. In India, here JJ Act defined do's and don'ts for children and police. So what are the according to section 10 rule 18, it's over there. I think we can send these soft copies to participants. So just I want to read out some of the things. These are well known and familiar, and it's very good if this section is implemented properly. So in our country, even they are in conflict with law, their rights are going to be protected and safeguarded. So child to be taken a child-friendly corner, not room, at least corner. What is the child-friendly? They defined it very well. And Juvenile Justice Board, every district is having JJB, and district judge is the chairperson of that Juvenile Justice Board. So right now in India, the entire nation, they are having JJBs. And this child, whether it's boy or girl, within 24 hours, if they committed any offense, within 24 hours, they are supposed to produce between JJB and Child Welfare Protection Officer, CWPO. It should be, he or she should be in plain clothes. And other points also there. So medical assistance provider or interpreter, because language is the biggest barrier. So India is a big country and multilingual, so it's very difficult for child, because you can imagine that a child travels across the country, and in street situation they commit a petty offense, or they are with their parents, or even migrant labor. We saw in this pandemic how people moved from one place to one other. So the language and other difficulties will the barrier, because their innocence, they are unable to prove their innocence. So it's very it's a must. And district legal service authorities, we know that in India every child is women and children, they can avail free legal services. So it's a compulsory, mandatory to inform to DLSA, District Legal Services Authority, about these children. And don'ts, what are the things police department, it's for police, they are not supposed to do. No FIR is to be registered against a CCL except in a heinous offense or offense committed jointly with an adult. FIR should not be there. Child should not be kept in police station or lockup or an adult jail. This is what I explained. Though it's well defined, in practice it's not happening in our own country, in our own national capital. Child will not be handcuffed, chained. Child shall not be asked to sign any statement, and all these things. Next. So now we can discuss about what are the alternatives things. Let us take example of Laos. Every village has a mediation unit where the cases covering children are heard by the juvenile mediation unit, where village officials, village elders, parents of the offenders, so on. So it's explained over there that the mediation process will allow the victim to air their grievance while ensuring that the juvenile is explained the consequences of the offense. Further, the settlement is arrived upon consent of both parties, thereby allowing for acceptance of the settlement. It takes a village to raise a child. It's about laws. It can be applicable in the entire world, but due to population, dense population, and due to all other factors, sometimes these village panchayats, we know about the Kap Panchayat and other panchayats. It's just like that system, but there it's successful. So here we are having entire mechanism, but child should be treated as the positive thing from this. I want to suggest that it should be raised. Take a village to raise a child, just like at least a family and neighborhood should take a responsibility, but not total justice system here, for example, in our country. But this is a good example. And next point is reintegration. Seeks to ensure that the children in conflict with law are rehabilitated and reintegrated into society without any discrimination or stigma, so as to not to become repeat offenders. What happens when a juvenile is committed some offense or some tag is there, so it and the peer pressure and the stigma, they will repeat it. So some in JJ Act and other acts also, how we should reintegrate them and the society should accept them. So what are the measures? Provide schooling and education, provide vocational training center, provide financial assistance and encourage self-employment, recreational and therapeutic center, sensitization of community, and family or community support. All these measures, any one or two or combinedly total measures, then they will not become a repeated offenders. So now let us focus on, this is about our country, India. Now let us focus on what are the neighboring countries, how they define child and what are other good or bad practices over there. So this is juvenile justice in South Asia, UNICEF South Asia 2006. This is the assessment from UNICEF. In Sri Lanka and Bangladesh, a juvenile is defined as a person under the age of 16. India, Nepal, and Maldives have established specialized juvenile police unit. This is what SJPU. These three countries, they established. Restrictions are placed on the use of handcuffs in Afghanistan, India, Nepal, Pakistan, and Bhutan. In Afghanistan, Bangladesh, India, and Sri Lanka, police have the authority to release children on bail into custody of their parents. So I don't need to explain these things. It's very easy to understand. Bhutan does not provide for a fully separate juvenile court nor the option of separate courts. Children above 8 in Sri Lanka are subject to life imprisonment in certain listed offences. This is the sad state. In our country, we know that below 7 years, it's 8 years in, I think it's not amended till now. So in Sri Lanka, they treat 8 and above as adult in certain offences. Life imprisonment is also there. Sri Lanka permits court-imposed orders of corporal punishment against boys. Afghanistan, Maldives, and Pakistan, the girls are detained with adult females. Oh, so this is the situation of our neighboring countries. Now, till now we discussed about CCL, children in conflict with law. Now we are going to discuss about children in contact with law. in JJ Act, it is defined as children CNCP, children in need of care and protection. Here, internationally, children in contact with law refers to any child who is vulnerable. Nothing to do with conflict with law. They are found with families at risk in state situation and institutions. Most of us know about these type of families. Street children, orphaned or abandoned and destitute children, working children, abused children, children who are victims of commercial sexual exploitation and trafficking, children engaging in substance abuse, children in conflict and disaster situation, children in families at risk, differently abled children, mentally ill children, HIV and AIDS affected, infected children, juveniles in conflict with law. This last point, all other points are there. There may be 2 or 3 in combined state also. But how come that children in conflict with law, they will become children in contact with law or CNCP? Because they are also vulnerable. So though they did an offense, law treats them as a CNCP children. So all these categories, they come under children in contact with law. So how can we improve their situation? Family support is important for social, mental and physical development of children. Adequate care and protection can ensure only by considering institutionalization of children as a last resort. Necessity of principle and deinstitutionalization. Now, though there is no other alternative for a family, but institution should is a best option, but it's a last resort. Because we can't replace the protection of parents. This is what law says, not it's my emotional or personal opinion. So below 18 years or below 16 years in some cases, children should be treated as a child only, and they need this protection and support. So it's an internationally accepted principle that no child should be kept or institutionalized unless and until it is the last option. So, though it is a last option, but how should they be treated? So, institutional care and community care. Institutional care seeks to provide care by establishing institutions for care of general and specific category of children as primary or secondary option. Here, suitability principles. 16 principles are defined in Juvenile Justice Act also, and UNCRC, they defined in the entire 45 articles about how we should treat a child. So community care and non-institutional care seeks to provide community-based care by encouraging support from the family, relatives, friends, and neighborhood. So one category of children, they are kept in institutional care, and other category, the Child Welfare Committee in India, it will decide whether we should send the child to institution or under community care or sponsorship or foster care. So here CWC will decide, Child Welfare Committee will decide whether the child belongs to even CCL or CNCP, conflict with law, or they below 18 years, below 16 years in other than heinous offense. The children are sent to Child Welfare Committee only. From there, there it will be decided after a lot of investigation. Then they will suggest them, they will send them to either to JJB, Juvenile Justice Board, if they committed any offense. Otherwise, they are sent to institutional care as a last option. This is the procedure we follow in India. India, children of women prisoners. Now, think about the children who are born and brought up in the jail and who are with, we know that mother is a natural guardian below 6 years. So a lot of times women prisoners, they will keep their children with them. So in one of the case, R.D. Upadhyaya was a state of Andhra Pradesh. Women are the primary and many times sole caregivers for minor children. Therefore, the imprisonment of mothers cannot be considered in isolation. Indian Supreme Court ruled on the basic amenities to be made available to children of women prisoners. The prison manual of 2016 reflects the same. Indian prisons have to provide crèche for children below the age of 3 and nursery for children below the age of 6. Clothing, diet, education and recreational facilities are also made available in prisons. In total, 1,732 women and 1,999, almost 2,000 children in jails according to 2018 data. So I met some of the children in the hard women's jail. Though they might be very happy and they're playing, but it's very hard to see children growing up in jails. So it's a very difficult stage for them also to cope up the atmosphere over there. So institutionalization should be last resort according to me also, because there they will provide everything, food, clothing and all other facilities. Sometimes children with families, they are unable to get, but natural surroundings and affection, it's we can't replace with any sort of institutional care and providing money and food and education. So family should be the first priority to take care of children. So here one more thing, good practices, about good practice, just like Laos. In Nepal, community-based rehabilitation of children with development disabilities. The community-based rehabilitation model developed to prevent institutionalization by providing support to children with disabilities and their carers in a number of settings. It comprises of direct services, advocacy and social inclusion. Direct services is providing preventive health care and corrective surgery, training to parents and all. Advocacy is creating awareness to integrate 10,000 children with disability into mainstream schools. And social inclusion is providing vocational training and all. So microfinances, employment opportunities. This is in community-based disabilities. This is one of the good practices in Nepal. So now, what are the challenges? Poor implementation of the protection framework, lack of public awareness of child protection laws. We know that, for example, in our country also, people think that equipping children about their rights are parents. Even parents, sometimes they feel that they should not be known about 100 also. Because it's awareness about child rights is not encouraging them to react or become violent, because we should know that what laws should be done. Forget about children, even stakeholders, police officials, lot of advocates, they don't know about what exactly child rights are there. So Indian Constitution provided every citizen, including child, that our rights are well defined. But awareness, lack of awareness is there. Lack of resources and facilities for functioning of child protection system. For example, child welfare committees and JJBs, even commissions in our country and other countries around us, they don't have child-friendly budget or no definition in our finances, so no allocation for the entire mechanism. Not only stakeholders of this implementation of these laws, but entire mechanism, there is no defined budget allocation. Lack of regular training and sensitization of personnel. right from police department, if we take CCL, or child welfare committees, orphanages, institutions, and to highest courts. The sensitization and regular training is not there. Shortage of trained staff and personnel, lack of institutional and community-based options in comparison to the number of beneficiaries. All these are challenges in front of us. And way forward, how can we go ahead? Provide training to all personnel, connect care institution to skill development schemes. Because sometimes children are kept in these observation homes, and at least minimum 6 months to 3 years they are there, so they can equip any skill. For example, in India, PMKVY is a very successful program, Pradhan Mantri Kaushal Vikas Yojana. So there are only 3 months courses are there. So they should be equipped, whether they are conflict with law children or direct CNCP. Periodic data collection and research, and increase sponsorship to families to support children. According to Section 45 of JJ Act, not about reservations and all, if the children are vulnerable, so single parent or disability scheme under reservations, lot of schemes are there, but family supports, even in this pandemic time, the migrant laborer for their children also. So specifically the families of the children below 18 years, they should be given different support system. Encourage community-based intervention through public and NGO participation, increase data collection and conduct vulnerability mapping and collect good practices. So all these measures, if followed by different states and different countries and all stakeholders who are supposed to protect child rights, then obviously we can see a good, bright future for children. And this is about my work. In last 1.5 years, I traveled more than 10 states, and we our National Commission for Protection of Child Rights, we conducted more than 60 camps in aspirational districts. We know that Niti Aayog defined our 700 plus districts in our country as aspirational districts. More than 115 districts are defined as a aspirate. They compared on 6 factors about food, health, nutrition and all, education. And they decided that these are the not backward districts. Earlier the term we used to use backward or underdeveloped. Now they are aspirational districts. So I attended 9 benches and camps. So more than 6,000 complaints we addressed. We used to conduct our camps from morning 10 to 6. For example, I went to Wayanad, I went to West Sikkim and Riboi, somewhere in Jharkhand also. It took us to travel by road to travel more than 7 to 8 hours to reach that aspirational district. But I felt very happy when I see the children coming forward over there in that aspirational districts with various complaints. So I redressed 800 plus complaints then and there itself, spot redressal. This is the Tihar jail thing. 297 juveniles identified through Delhi jail visits, and visited different childcare institutions and Anganwadis. Before becoming a member here, I used to work as a social worker also from my student days. So I spent more than 6 months in one of the orphanage when I was coordinator of ILO Street Children Project. I used to run in 1995-96. This is about 95-96 in Hyderabad. So and I used to visit observation homes, and I used to tell storytelling to them as a student. when I was a student. So my appeal to you all is that listening to these type of talks, webinars, and you may attend hundreds of talks or webinars, or your professors may enlighten you about acts, but working with children uh, who are less privileged than us, or who are in CCL children, especially, you need permission to enter and contact with them. But children are there in enter your surroundings also. Please talk to them, work with them, just spend some time with them in a positive way. It will give lot of um, self-confidence to them. And if I am getting the benefit of working with children when I was student, some positive energy will work on you when you work for others selflessly, and one day you will reach to such a position that you can help thousands of children. This is example of me, because I was very happy when I used to work with children. After 25 years working in different fields and going to Supreme Court, I am blessed to get this post, and now I met thousands of kids as an official, but still I cherish the memories when I used to work as a volunteer, with my own free will. No mentor was there, no classes I heard anything about all these things, but I visited orphanages on my own. I visited to observation homes as an advocate. I used to go to jail and old age homes also, not only children. But that passion also, sometimes it will work as a tool to for you to equip your skill also. So if your passion will become your profession, and then you will cherish those moments also as a teenager, or as a student, as a youngster, you can become a youthful, as a young adult, as a big brother or sister to your siblings or children below 18 years, though you are at the age of 80. Though I am after 50, 5 decades, I am still, whenever I met children below 18 years, I feel the fresh energy inside me. So thank you so much, ISLR, and I am very happy and glad to talk about children, because the very precious age is below 18 years, and below 12 years children will learn about everything. Now it has come to below 8 years only, they will learn everything. So it's our responsibility to educate them and educate ourselves about what exactly child rights are. So thank you so much.
Thank you so much, ma'am. Thank you for enlightening us with these lovely sessions. Your journey, as well as this particular session, has been truly, you know, a good guide. Like, we get to know in the law colleges about all these problems, but we hardly get an opportunity to know it from someone who has been working in this field. So it is very kind of you to enlighten us with your words. Thank you so much. Now we move on to the question answer session. If somebody has a question, please unmute yourself and ask the question. Anybody? Ashish sir, you had a question for ma'am? Okay,
Avantika,
so
please read it
yeah.
for ma'am. So
Yes.
Okay, I'll read it. Right. So, in view of increasing instances of crimes in child care homes in Muzaffarpur and increasing instances of disaster in last few years, what are the specific infrastructural and other challenges that arise in the context? More so, since they are children requiring care and protection as opposed to being treated as in conflict with law? Does the law currently bias against the children requiring care due to the infrastructural constraint? What can be the potential area of reform? So that's the question, ma'am.
Yeah, a very relevant question and good question indeed. So, Ashish, so it's not only about the Muzaffarpur case. In 2 days back, I was handling about a 14 years girl from Telangana. After repeated sexual abuse, afterwards also she is under protection of state institutions and hospitalized in the government hospital. She was under supervision of Barosa and she teams. A sad part was that she died last week. So sometimes, even though every mechanism is very good functioning, for example, I am giving the example of Telangana. Now about Muzaffarpur also, it's a time to think about children really, because we need to strengthen JJB and CWCs in a lot of states. Even formation of child welfare committees. They are there. Almost 10 years back, they formed a child welfare committee, and every 3 years they are extending. And I think in UP it's yet to form new committees and all. So we know how pressure is there on courts and all. So when there is a separate system, the system should be empowered. And about regarding finances also, unless and until you provide finances, all these temporary systems, they can't function. So JJBs and CWCs, we need, they should be equipped and empowered. Child welfare committees and juvenile justice boards. And every state and central budget should be child friendly. And right now I explained about child in conflict with law is a child who is in need of care and protection. They should be treated as, they should not be treated as a criminals, because a child is a child. Because of all these scarcities and different 1,000 reasons might be there, but he or she is a child. If they committed any offense, they should be treated as a innocent soul only. It's even our constitution defends like that. IPC defend, unless and until the crime is proved, the accused is given a right to live with respect. So the child should be treated as a child only, not as a child in conflict with law. Though that he will become the category and he'll send to observation homes, but they should be treated as a child. And more volunteers should come forward, more NGOs should be, it's not only about human rights violation and women rights violation. Child rights are the most neglected part in our country, because children are treated as a tools to earn money, either sending them as a child labor or to beg, or to misuse them or exploit them or use them as a tools to earn money. This is what a lot of people are doing now, whether it is awareness or whether it is institutions or homes, because after implementation of JJ Act, every home is supposed to be registered. But how many homes are running unauthorized? It's a very sad situation, but we are trying our level best. Even our counterparts are trying our level best. And this, we should use this pandemic as a tool to protect our children. It's a nice question raised by you. I don't think I gave a proper reply to satisfy your query, but this is what I want to say, that we need finances, we need human resources, we need a society who should give respect to our children, because we all know all chotus who are helping us. Personally, I feel that my mother taught me this one good this thing, virtue, that she never ever allowed any child to work. I belong to a rural background. I am from an agriculture family background, and she never allowed any child to work in our farms also. So this is the virtue I learned, and I never allowed. I took a break and I brought my 2 kids on my own. I never ever kept a child labor, and now today there is no guilt inside me. Otherwise, lot of our officials also, they, because we can't speak when we ourselves are doing some crime under the disguise of helping the poor family. Lot of poor families are there. We hire them and we exploit them and their children also. So this is not the devils are not in the somewhere else. They are inside us. They are inside us when we see some child is there and he is doing some thing which is not good for him or her. We just overlook it and we'll just go away without any guilt. So all of us are, we should become a stakeholder. Society should become this drug abuse right now and internet usage also. They are more vulnerable. So my appeal to all elder siblings, uncles, aunties, or some you might be having a children in your contact, a child, or let us become aware citizens, because our entire nation using children for awareness programs. For greenery, they are supposed to tell. For Swachh Bharat, they are supposed to become a role models. But what about we adults? We are supposed to protect their rights. So this is my humble appeal to you all, youngsters. Let us not put more burden on children. कहीं पर भी डोमेस्टिक वायलेंस हो रही है तो उसको बचाने के लिए भी बच्चा होता है आजकल एड्स में. How much we expect from them? दिवाली पटाखे, मांझा, kites नहीं उड़ाना, school नहीं जाना. You are not supposed to go school, but you are supposed to become a role model and preach your elders that pandemic से बचने के लिए बच्चे बताना पड़ेगा हमारे मुंह पे मास्क लगाना है. So we are overburdening them. And it's about a normal family and it's about normal एक परिवार के अंदर जो बच्चा है उनके बारे में मैं बता रही हूँ. Think about children in street situation. Think about them who are vulnerable and about homes also. Supreme Court took cognizance, so moto cognizance in this particular matter, and in one more case where in Chennai home, more than 37 kids they tested positive. So apex body of our nation, Supreme Court, it's taking cognizance so moto, and commissions like us who are monitoring agencies and all state governments and central government, WCD ministry issued more than 3 advisories particularly for children. Even though all these mishaps and these institutions, as one of institutions, they are doing very good work, but we can't deny that lot of institutions are misusing children to raise their funds or to do, though their intentions are good, but their rights should be protected. So as a, not as a member NCPCR, it's my personal opinion that it's better, let us look forward for deinstitutionalization and foster care, sponsorship, families, adoptions, we should encourage that, and child-friendly society should be there. Not only child-friendly government, child-friendly society should be there.
Thank you so much, ma'am. We have one more question from Rida. What are your views on the gender neutrality of rape laws?
As a after Nirbhaya, when gender laws were amended, we were part of that committees formed, and our suggestions they took in Burma committee. So gender neutral rape laws, because child is a child, and whenever laws are stricter than the accused or the suspected criminals, they will focus more on other type of vulnerabilities. So because right from the beginning, though I used to work for property rights and women rights, but about children, it should be neutral only. Because even now the difference, the slight line between both genders, it's disappearing. So whether it is a sodomy or a rape, and even rape laws they amended, because earlier it's about the character of the victim, it's about intercourse, it's about medical certificate and all. Now it's very clear. Doing anything with a child, according to about this rape and all, it should be general neutral. And I support and I am advocate also for that.
So thank you so much.
We need to, one more point I want to add, the awareness about gender discrimination and women rights, girl child rights, beti bachao, beti padhao, ये सब ठीक है. But beta bachao, what about sodomy? People are using boys like sex toys. Some of countries I discussed, even in India also, and boys, our boys, they were taught that not to speak, not to cry. So we need to focus on that also. They parents, lot of parents, including me, will not allow our girls to go out and all, but we'll allow our boys, even he is under 10 also, to send at any place, and vulnerable. He is so vulnerable now. So let us focus on gender discrimination. So we should equip our girls, we should sensitize our boys, and about sexual assault, both genders, children are vulnerable. We should not think about gender specific talks. When it comes to safety of children, till the age of 12 or 13, common session should be there, and till below 12 years, we should not discriminate about these safety talks. Boys are also vulnerable. So we should not treat boys like 50% of our society, they are supposed to do some offense. They are supposed to become victims also, just like girls. So according to gender neutral thing, and even female accused, we should not differentiate about this gender and sexuality in this type of offenses.
Thank you so much, ma'am, for the lovely session. But due to lack of time, we have to move on to our next session. Thank you so much, ma'am, for taking out time for us. So, hello, am I audible?
Yes, it's audible.
Yeah, so now we introduce Basil Abu Rokba sir. He's an assistant professor in Marwadi University, Gujarat, and he's going to talk to us about the impact of sanction on the civilians in the time of pandemic. Over to you, sir.
Good afternoon, everyone. I am very glad to be here with the Indian Society for Legal Research, and which give me this opportunity to be a part of this session. And I will say thank you so much, Pragna ma'am, for this useful session which you shared with us about the child protection. And I hope I am audible and everyone can hear me right now.
Yes, sir, we can hear you.
Yes, thank you so much. Actually, in fact, I prefer to choose a topic that touches the reality of the global reality, I mean. As many regions around the world nowadays has or witnesses armed conflicts at the same time of the spread of coronavirus, COVID-19, I mean. So as we can see every day by the news is that many regions around the world nowadays has or have armed conflicts, even if it's international armed conflicts or internal armed conflicts like civil wars. And we know, according to the international law and according to the international humanitarian law, that those type of laws interferes to protect the civilians in the place or in the regions of armed conflicts. And according to the United Nations Organization Charter and according to the international law or the rules of international law, we know and we can see a mechanism, a system called sanctions. So right now I'm going to start my lecture, and please just allow me to share my screen. Hello, excuse me, just give me the permission to share my screen,
sir.
please.
Sir, just a
Yes.
moment.
Okay, take your time.
Can you do it now?
No, because the host disabled participants screen sharing.
Okay,
So,
okay, just a moment, sir. It's a
okay,
technical
I am the
fault.
host right now. Yes, yes.
Yeah.
Yes. So let me introduce myself again. My name is Basil Abrukba, and I am a PhD scholar of international law at Marwad University. And I completed my LLM from Osmania University, BG College of Law. So today's my session is, and the subject is the impact of sanctions on civilians in the time of pandemic. And as I said, I choose this topic because I need to touch the reality or the global reality around the world according to the spreading of COVID-19. So I divided the topic into introduction. So we are going to speak about the meaning of sanctions, and then how does sanctions imposed against any ward. Then we are going to talk about the types of these sanctions, and then the reasons for sanctioning and the purpose of sanctions, and the most important thing, what is the impact of sanctions on civilians, especially during the time of pandemic, and what is the impact of sanctions on human rights in general. So we are going to speak about the meaning of sanctions according to the international law and according to the United Nations Charter, which adopted in 1945. So a mechanism called imposing sanctions against the states or against the organization which don't fulfill its international obligations. So in this time, or in this time, United Nations Organization and the other states member of United Nations Organization can impose sanctions against such a state or against such organization. So the meaning of sanction, as we can see, that there is no authoritative definition in international relations of sanctions. There is no a complete definition of sanctions up to today, but just we can see the definition of sanctions by practicing this system or this international system. But one commonly used definition is the deliberate government-inspired withdrawal or threat of withdrawal of customary trade or financial relations. So, the purpose of sanctions can vary, but generally can be said to pressurize the target to comply with the sanctions demand. The definition focuses on the economic measures and excludes punitive diplomatic and political measures. International sanctions and are political and economic decisions that form part of diplomatic efforts against a state or against organization by nations, multilateral or regional organization, either or defense of national security interests of international law, and to shield them from threats to international peace and security. But on the one hand, it's on the one hand, and military measures, we also have military measures. So right now we can see that we can impose political and economic sanctions against any ward, and we can use the military measures On the other hand, this definition also excludes private measures of boycott and other such actions. Powerful states, particularly the United States of America and European Union, tend to impose economic sanctions, and these are usual coordinated. The United States and the European Union also try to secure the UN Security Council approval for their sanctions. Under international law, the respective regimes applicable for sanctions differ depending on whether the sanctions is ordered by the UN Security Council, the withdrawal of customary economic relations, covers just a minute, covers a spectrum of activities from a general halting of trade embargo, which is called embargo, to different types of measures directed against particular part or a sector of a state. So in this case, we can see that sanctions can imposed against a state or against just one part of state, one sector of that state. For example, we can impose just sanctions against the military of that state or against the Ministry of Defense of that state. So the other states can't import or export military staffs from that state or to that state or country. So this is the widely meaning of sanctions. How can or how does the sanctions imposed? What is the imposition of sanctions? As I said, under the Charter of United Nations Organization and under the rules of international law, throughout the preservation of international peace and stability, the Security Council has primary responsibility. There are 15 members and 1 vote per member. All member states shall comply with Council resolution under the Charter of the United Nations Organization. In deciding whether there is a threat to peace or act of aggression, the Security Council takes the lead and it advises the parties to the conflict to pressure a peaceful settlement of the disputes and purposes modification approaches or negotiation terms. In certain cases, the Security Council can use sanctions or even allow the use of force to maintain or restore international peace and security. As we can see here, that the United Nations Organization Security Council, especially, I'm talking about the Security Council, in case we have an armed conflict between 2 countries or internal armed conflict, the Security Council give the chance to the parties of the conflict to settle that conflict peacefully by mediation, negotiations, or any another kind of peaceful settlement of disputes. But if the 2 parties don't comply to the decision of the Security Council, as I can say, then the Security Council can take the decision to imposing sanctions against the whole country or against the 2 parties of the conflict. The use of the mandatory sanctions is intended to apply pressure or on a state or entity to comply with the objectives set by the Security Council without restoring to the use of force. So we can see that the Security Council or the other countries, parties to the United Nations Organization, can use this mechanism against one country just to avoid using, as I can say, force against that state. So they can use sanctions against that country instead of using force against it. Sanctions thus offer the Security Council an important instrument to enforce its decision. According to the Charter of the United Nations Organization, actions with respect to the threats to the peace, breaches of the peace, and acts of aggression, which contain the following articles. So, according to the Article 39 of the United Nations Organization Charter, the Security Council shall determine the existence of any threat to the peace, breach of the peace, or act of aggression, and shall make recommendations or decide what measures shall be taken in accordance with Article 41 and Article 42 to maintain or to restore international peace and security. According to Article 40, in order to prevent an aggravation of the situation, the Security Council may, before making the recommendations or deciding upon the measures provided for in Article 39, call upon the parties concerned to comply with such provisional measures as it deems necessary or desirable. Such provisional measures shall be without prejudice to the rights, claims, or position of the parties concerned. The Security Council shall duly take account of failure to comply with such provisional measures. And according to the Article 41, the Security Council may decide what measures not involving the use of force are to be employed to give effect to its decision. And it may call upon the members of the United Nations to apply such measures. These may include complete or partial interpretation of economic relations and of rail, sea, air, postal, telegraphic, radio, and other means of communication, and the servants of diplomatic relations. And we have also Article 42, and we have also Article 43 that can UN Security Council use against the parties who has who have conflict, or against the countries. Right now, we saw the mechanism of imposing sanctions under the UN Security Council, and we need to know what type of sanctions we have. Actually, the international community can use sanctions to change the behavior of a country or regime in case, yes.
Somebody has left the mic unmute. Kindly please see.
Excuse me. Yes. May I complete, please?
Yes, sir. Please continue.
Yes, thank you so much. So the types of sanctions, the international community can use sanctions to change the behavior of a country or regime in cases where that country or regime is violating the human rights, waging war, or endangering international peace and security. Actually, there are several types of sanctions. First of all, we have the diplomatic sanctions. Diplomatic sanctions are political measures taken to express disapproval or displeasure at the certain actions through diplomatic and political means, rather than affecting economic or military relations. Measures include limitations or cancellations of high-level government visits, or explaining or withdrawing diplomatic missions or staff. This kind of sanctions, which I mean diplomatic sanctions, actually is it's really common nowadays. We can see that according to the sanctions imposing against Syrian Arab Republic, which is my country that I came from, Syria, actually, nowadays we can see that the Security Council and the other member states of the United Nations organization imposed several kinds of sanctions against my country, Syria, and this diplomatic sanctions, it's one of that sanctions which imposed against my country, Syria, especially from the European Union or from United States of America. So they don't have, or we don't have, like Syrians right now, a diplomatic relations between us and between us, like Syrians, and between European Union or United States of America or Canada or Australia and the other countries. The second type of sanctions is the economic sanctions. Actually, it's really important to know what is the meaning of economic sanctions against one country or against one organization. Economic sanctions can vary from imposing import duties on goods or blocking the export of certain goods from the target country to a full naval blockade of the target ports in an effort to verify and curb or block specified imported goods. Well-known example of economic sanctions include we have such experiences of economic sanctions against some states The first one is the United Nations sanctions against South Africa, the United Nations sanctions against Zimbabwe, United Nations sanctions against Iraq 1990 and up to 2003. Actually it's still up to date. The United States embargo against Cuba, and the United Nations and United States of America, European Union sanctions against Syrian Arab Republic. The third type of sanctions is military sanctions. Similarly, military sanctions can range from carefully targeted military strikes to degrade a nation's conventional or non-conventional capabilities to the less aggressive form of an arms embargo to cut off supplies of arms or dual-use items. So military sanctions, it's simply meaning that the countries which impose sanctions against such country or against entities or against organization, in the time of military sanctions, they don't send such items, as I can say, to the country under the sanctions. We also have sport sanctions and sanctions on individuals and sanctions on environment. But let me just mention the sanctions on individuals, please. The United Nations Security Council can implement sanctions on political leaders or economic individuals. These persons usually find ways of evading their sanctions because of political connections within their nation. This type of sanctions nowadays, the member states of a United Nations organization and the United Nations Organization Security Council use this type of sanctions also against individuals in my country, Syria, and against individuals in Iran, Iraq, and Cuba, and North Korea as well, and against Russia. As we can see, according to the resolutions of United Nations Security Council, which imposing by time to time against such individuals. After we know the meaning of sanctions and after we know the type of sanctions, let's see what is the reasons for such kind of sanctions. Sanctions formulations are designed into three categories. The category are used to differentiate between the political contexts due to the global nature of the act. The first category involves such sanctions that are designed to force cooperation with international law. This can be seen in the sanctions placed on Iraq in resolution number 661. It was in August 1990, after the initial invasion of neighboring Kuwait. The United Nations Organization placed an embargo on the nation in an attempt to prevent armed conflict between Iraq and Kuwait. Resolution also 665 and Resolution 670 were further added, certaining both naval and air blockade on Iraq. The purpose of the initial sanctions was to coerce Iraq into following international law, which include the recognizing sovereignty of Kuwait. The second category of design is those sanctions with the purpose of contain a threat to peace within a geographical boundary. The 2010 Iran nuclear proliferation debate is a contemporary example for the second category of the reasoning of sanctioning. The third category involves the United Nations Security Council condemnation of action of a specific action or policy of a non-member nation. And this is the reason of sanction. After we saw the reason of sanction, why do we impose sanctions? Why do the other countries impose sanctions against one country? We can also see the purpose of sanctions. We need to understand what is the purpose of sanctions. The purpose of sanctions is often to change undesirable behavior of a country, like United Nations Security Council say, we are imposing sanctions against Syria, just we need to change the undesirable behavior according to the Security Council and according to the other member states of the Security Council. The second purpose is to limit opportunities for undesirable behavior, like Iran, extensive restriction on technology, knowledge, and the nuclear sector. The member states of United Nations Security Council, they imposing sanctions against Iran just to extensive restrictions on technology, knowledge, and the nuclear sector. The third one is to deter other countries from choosing an undesirable course of action. And as mentioned, by the purpose of sanctions, if an international obligation are violated, certain penalties or sanctions may be applied independently, and subsequently the obligation to repair the material procedure caused. Right now, the most important thing, we need to know what is the impact of such sanctions, especially economic sanctions on civilians. Economic sanctions are one of the certain tools that one country or a group of countries or by the Security Council may resort to a specific country to force it fulfilling its international obligations. This type of procedures appeared after the Cold War, after the 1960s. And it was imposed against several countries such as Iraq, as a measure imposed against Syria also, and other countries like Iran, Cuba, and as I said, North Korea. And nowadays we can see that like such sanctions, against Russia. Economic sanctions include a ban on importing, exporting, and financing of a country that falls under such kind of sanctions. But an important question arises. As it's known, the state consists of three components: population, land, government. We know that the state consists of three components: population, land, and government. We need to know what kind of side effects that sanctions or what is the impact of the economic sanctions on civilians. As I mentioned, population in this study as I mentioned about the population as a part of the components of a country, it's really important. It's really important that they are. It's really important to know that the civilians, they are the largest segment that will be damaged by the effects of these sanctions. Reports from Syria nowadays have proven that civilians today are living in difficult humanitarian conditions due to the international sanctions imposed against Syria, especially from the point of, as I can say, especially in the economic way. The legality of sanctions has been discussed in many books, actually, and articles, especially from a humanitarian point of view. And as stated by a book entitled Political Gain and Civilians' Pain, Humanitarian Impact of Economic Sanctions by Thomas George Weiss and David Cortez, they said that these political and economic realities of sanctions have become further complicated by humanitarian considerations, especially concern about the harmful effect of sanctions on the effective functioning of health and other social support services. Damages to the social safety net have been mostly thoroughly documented in Iraq, but present in all cases, illustrating the disturbing irony that appears to operate in the use of economic sanctions. On the one hand, such measures are imposed with greater regularity, often with an expressed relation of avoiding the hostility, more inhuman applications or of military forces. They said that using such economic sanctions, it's better than using the force or using army against one country. But actually, in fact, as I said, the reports from Syria nowadays and from Iraq in the past, the report says that the civilians suffered a lot from the economic sanctions. They suffering a lot from the economic sanctions, especially because in Syria, in my country, Syria, I mean, we used so many items coming from out. We export and import such items, but nowadays, because of the economic sanctions, we can't import such items from the European Union or from the United States of America or from the other countries. And just a minute. The impact of sanctions on human rights. As we saw that the impact of sanctions against civilians, they have human rights also. What is the meaning of a human right? Human rights are rights inherent to all human beings, regardless of gender, nationality, place of residency, sex, ethnicity, religion, color, and other categorization. Thus, human rights are non-discriminatory, meaning that all human beings are entitled to human rights. Not all human beings experience them equally throughout the world. Many governments and individuals ignore human rights and grossly exploit other human beings. Human rights, there are a variety of human rights, including civil rights, such as the right to life, liberty, and security, political rights, like rights to the protection of the law and equality before the law, economic rights, including rights to work, to own property, and to receive equal pay, social rights, like rights to education and consisting marriages, cultural rights, and we have collective rights like the rights to self-determination, and cultural rights, including the right to freely participate in their cultural community. Why I mentioned about the human rights? Right to health, or as I can say, the basic rights of human beings were clarified in the United Nations Charter and in the Universal Declaration of Human Rights, 1948. And restrictions were imposed on violations, either they were states, individuals, or entities. The most obvious of these restrictions was the imposition of international sanctions against states or individuals who commit genocide or acts against humans. International sanctions have always been a tool for states to use against a particular state to force it to comply with its international obligations. A number of penalties have been introduced over the past and present centuries on groups of countries, especially those with internal conflicts. But there is the question, are sanctions an effective tool for stopping wars and alleviating civilian suffering? This is the most important questions we have today. Are sanctions an effective tool for stopping wars and alleviating civilian suffering? Evidence has shown that sanctions often threaten civilians. Sanctions often threaten civilians and have an impact on them, especially in their everyday life, because of a lack of resources they don't have or they don't find it every day. They adversely affect health and access to food and medicine. So let's see the impact of economic sanctions on human rights. The impact of economic sanctions on civilians has frequently been studied by public health specialists and specialized agencies of the United Nations Organization. This commentary explores some of the difficulties of the claim that sanctions constitute violations of human rights. The deprivation suffered by civilians population under sanctions regimes often are violations of economic, social, and cultural human rights. However, the attribution of responsibility for those violations to the senders of sanctions, I mean the countries which impose such sanctions, the UN Security Council or the US governments, for example, it's difficult to sustain, particularly in light of the efforts more productive approach to avoiding civilians' harm is to prefer, as a matter of policy, arms embargoes, serving of communications, and international criminal prosecutions over trade embargoes. Promising recommendations have been formulated regarding smart sanctions. Right now, we can see that there is something called smart sanctions, which target regimes, for example, rather than people, and positive sanctions in the form of incentives, health, and human rights. Professionals have specific and important tasks in the implementing such restructured approaches to sanctions. In this commentary, I consider the public health impacts of sanctions regimes in their political and legal context and examine several reform proposals designed to reduce their harmful effect on civilians. The article by Elizabeth Gibbons and Richard Garfield, The Impact of Economic Sanctions on Health and Human Rights in Haiti 1991 to 1994, in this regard, in this issue, given an excellent example of the collection and the presentation of data in support of their conclusion that economic sanctions in Haiti resulted in extensive violation of the rights of Haitian people or Haitian citizens. My purpose is to raise some of the legal and moral problem of treating the civil impact of sanctions as human rights violations, and to argue a collaborative effort of public health and human rights professionals with policymakers to influence the way sanctions are applied. Human rights, we can say, based on the reports came from UNHCR and United Nations Organization and the other specialized agencies, that human rights which may be violated by economic embargoes or by economic sanctions. We have right to life can be affected by the economic sanctions, a right to freedom of opinion and expression, right to educate food and to be free from hunger, right to the highest possible standard of physical and mental health, right to the provision of medical assistance and healthcare, and right to educate, clothing and housing, and as you can see up to the end, right to participate in the government, right to the social security. Sanctions during pandemic, the most important section of this study. As I explained previously, the negative effect of sanctions on civilians from a humanitarian side, if a country under international sanctions in the normal days, as we saw that the civilians suffered a lot from the economic and other kind of sanctions. Furthermore, those effects are multiplied in the time of pandemics that spread globally, as that country suffers under that sanctions more than the others because of the existence of the international blockade on it, and here the suffering of civilians being even more. Where the country under international sanctions is likely to suffer from a shortage of medical equipment needed to face such disease, which leads to a large and widespread outbreak of disease among civilians on that country under such kind of sanctions, especially in the poor places, I mean. Nowadays, Syria is under international sanctions, and globally, COVID-19 has spread widely, and the cases in Syria, it's also spreading very fast nowadays, and Syria is under economic sanctions. So what is the benefit of such sanctions, of such sanctions nowadays? A pandemic is there, civilians are suffering, maybe some civilians in Iran, Iraq, Syria, and Cuba or North Korea, they don't have as a health assistance, or they don't have the needed aid of health. So the impact of sanctions during pandemic, it's completely, as I can say, it's completely bad for civilians or for the other people in that countries under the sanctions. In Syrian Arab Republic, COVID-19 update from 15th of July up to 24th of July, that in Syria, 608 laboratory confirmed cases have been reported to the Ministry of Health to date. 1 case in Tartus and 7 cases in Daraa, 9 cases in Suwaida, 9 cases in Homs, and 10 in Hama, 29 in Latakia. Those cases where the location had yet been announced. In total, 214 new cases have been announced since the last report. The Ministry of Health has also announced 35 fatalities, an increase of the 19 since the last report. According to available data, nearly 28% of cases presented as several critical requiring hospitalization, and including in some cases oxygen or mechanical ventilation and ICU units. In addition, of particular concern is that according to MOH, 44 healthcare workers, 8% of reported cases have tested positive for COVID-19. So we can see that COVID-19 nowadays in Syria, it's spreading among the healthcare workers, among the doctors, among the nurses, an increase of 26 since the last reports. This includes 34 in Damascus, the capital city, 6 in rural Damascus, 2 in Aleppo also. Healthcare workers and underscores given Syria's fragile healthcare system, which already insufficient numbers of qualified healthcare personnel, the potential for its overstretched healthcare capacity to be further compromised. What I mean right now, that most of the doctors nowadays in Syria especially, they leave the country to another country. So since the last update, humanitarian actors have also received unverified reports concerning additional possible cases, and information indicates that in some areas, existing healthcare facilities have been unable to absorb all suspected cases, and or healthcare facilities are suspending surgeries or adapting wards to accommodate an increasing number of COVID-19 patients. While the United Nations is not in a position to verify this information, it's of note that official cases confirmed by the MOH have increased more than 100% in July, and the sources of 277 cases to date remains unknown, potentially indicating that community transmission is now widespread globally, even the most advanced healthcare system. So what is the situation in Syria right now, which it's under such economic sanctions or healthcare sanctions also? Reports indicates that medical institutions, this is the most important things also here, and Syria have been significantly affected by the war. So how will a country like Syria today will face such disease? The main purpose of such sanctions imposed against Syria after 9 or 10 years of war there is appreciably to destroy the lives of ordinary people in hopes they will rise up in favor of whatever regime or the government change Washington is looking for, actually. In conclusion, and I'm sorry if I took more time, in countries that are heavily dependent on imports and are hastily enforced and supplemented by other socio-economic constraints, multilateral and systematic trade sanctions have a significant effect on public health. Iraq, for example, had all of these influences, and Iraq was particularly vulnerable. Haiti has been involved in many disputes between the families, for example, concurrently, and after sanctions were lifted, every sanction, a nation can compensate the loss of its revenue by way of humanitarian aid, which ensure that for several years after the end of sanctions, economic, social, and political instabilities persist, and the crisis may be extended. Non-governmental organizations which provide assistance for the civilians need to make a close relationship with those authorities who are involved with the human rights in order to re-identify the power and resources of the country and its people. Such approaches require creativity and leadership, and objectives of economic sanctions also need to be more accurate and clear. On the other hand, sanctioning authorities are not totally free in devising these sanctions, and the need to consider the basic of human rights. A review of the provisionally sanctioning states show that economic sanctions have been able to reach the goals for which they were once devised. In most cases, they caused more damage on health, welfare, and lives of a common people. Therefore, through making sanctions targeted accurately meant mentioning sanctions excluded goods, humanitarian measures, and devising national policies for the support of vulnerable groups using reasonable healthcare actions. One can mitigate the humanitarian damages resulting from sanctions, particularly smart sanctions. In this way, loss of lives would not occur, and the sanctioned country would be repelled more easily in the future. Thank you so much. So up to now, I can conclude my session about the impact of economic sanctions or the impact of sanctions on civilians in the time of pandemic, which I want to add, please, just for a minute. Like the reports from Syrian Arab Republic nowadays show us that civilians, especially in the poor places, suffer too much from the side effect of sanctions or from the impact of sanctions, because as I said, and as I mentioned in my article, that civilians in Syria today and the hospitals in Syria damaged or has a wide damage from the war which occurred in Syria or which happened in Syria 10 years ago. Thank you so much, and I really want to say thank you to the Indian Society for Legal Research to give me this opportunity to be a part of the first virtual summer school about the international law in the time of pandemic. And I would like to say thank you so much, Pragna ma'am, about her session about child protection. Also, child protection in the time of pandemic and in a country under such sanctions, especially economic sanctions, it's really important. Also, children has a right to live along with the other people, and the children can have the impact of sanctions or the impact of pandemic can be widely or can be more than the other people, because children, they need a health care more than the other civilians in the society. Thank you so much.
Thank you, sir. Thank you for taking
you so
time for us and enlightening us with your lecture. It was really worth learning and knowing about the sanctions in the time of pandemic. And if anybody our participants have any question, please ask, sir. Manya Anand has a question. Manya, please unmute yourself and ask the question to sir.
Good afternoon, sir.
Good afternoon.
I think I'm audible. Yeah, so the question is, what alternative means can be implemented instead of sanctions to hold a state accountable for its non-performance of its obligations in the international sphere of influence? Instead of sanctions, what the state can do or what the international organization can go about?
Actually, it's a very important question. Thank you so much for this question. And instead of imposing sanctions against such a country or against a state, let's try to give the parties of the parties of the armed conflict, as I mean, let's try to give them a chance to settle that conflict peacefully. The other countries which imposing sanctions against one country, for example, like Syria or like Iran, let them try, or let the parties of the conflict try to settle such a conflict peacefully by, as I said, peaceful settlement of disputes. We have so many ways to settle the settlement peacefully, like negotiation. Let's try the negotiation. Let's try the mediation. Like we saw in Vietnam, in the Vietnam's war in 1965 or 1969. Yes, France tried its best to settle such disputes peacefully. They asked the parties of the Vietnamese civil war to come to Paris and try to have a negotiations between each others and try to highlight the points or highlight the demands which every party want to settle the disputes peacefully. So instead of imposing sanctions against one country, let's try to use the peaceful settlement of disputes. Let's try to give the Security Council its power. Why we use veto power every time when one, like in the case of Syria nowadays, we can see if Russia tried to settle this disputes peacefully, or if China or if European Union try to give a chance to settle this disputes peacefully, we can see that such country or some countries using a veto power against such resolution just to settle this disputes peacefully. Actually, we just need to use the peaceful settlements of disputes.
Thank you, sir. Manya, is your question answered?
Yes, ma'am. Thank you so much, sir.
Thank you so much. I hope that I give the right answer for your question.
Thank you, sir.
Yeah, we have one more question from Rida, and then because of lack of time, we have to move on to the next session. Rida, please
Yes, of course.
unmute yourself and ask. Rida?
Hello, sir. Very good morning. And thank you,
Hello,
sir.
good afternoon.
Thank you, sir. It was very informative session. On we got to know about various sanctions. And my question is to you that recently we have witnessed that in a pandemic situation, US put sanctions on China. There were very sanctions which was put on China. And recently in June, we have seen that it imposed a sanction that 25% tariff on 50 billion of Chinese export will be imposed. So my question is that how do you see this situation? Like as a beneficiary step or as a disaster for a nation's economic health? Thank you, sir.
If I understand your question, that US put sanctions on China, that it would impose a 25% tariff on 50 billion of Chinese exports. How do you see this situation as a beneficiary step or as a disaster for a nation's economic health? Actually, it's a disaster, actually.
Yes, sir.
It's a disaster for the nation's economic health. We know that China exports so many items, as I can say, of healthcare or items of like medicines or something like that. Imposing such kind of sanctions, actually, I don't know about the sanctions which US imposed against China, but it's a disaster for the nation's economic health. According to this question, I can tell you something that US also imposed sanctions against WHO. US imposed sanctions against WHO because they said that the WHO didn't say that China has a pandemic like COVID-19, and we know that COVID-19 was widely spreading around the world. US said China failed us, or they didn't tell us that they have a pandemic like COVID-19 and it's spreading widely nowadays. So according to your question, actually it's a disaster for the nation's economic health. It's a disaster for the nation's economic health. Thank you so much.
Thank you so much, sir.
Thank you so much.
It was a very fruitful lecture, and thank you for taking time for us. And now we move on to the thank you, sir. Now we move on to the third session, that is Judge Mohammad Goma. He is the judge at the Egyptian Council of State. Sir, please join us. And he will be talking about the effect of the pandemic on the execution of international administrative contract. Goma, sir, can you hear me?
Yes, of course. Good morning, everybody. I hope that everyone could hear me clearly.
Yes, sir.
Yes, it's clear.
Okay, I'd like first to thank the summer school for giving me the opportunity to participate at your summer school event this year. It's an honor. Today, I'd like to talk about a very interesting subject, which is the effects of the pandemic on the execution of the international administrative contracts. Firstly, I'd like to talk about the meaning of the administration. You hear me clearly or no?
Yes, sir.
Yes, sir.
Yes. I'd like to share my, I need the permission to share my file with you.
Just a moment, sir. We'll do it.
Okay.
Just a moment.
So you can share now.
Okay. Today we will talk about a very interesting subject. It's about the effects of the pandemic on the execution of the international administrative contract. Firstly, I'd like to explain or describe what the administrative contract. There is three conditions which should be satisfied to consider a contract as administrative one. First condition is that one of its parties should be a public person. Second one, the object of the contract should be related to a public service. And finally, the contract should include a certain condition which give exceptional power to the administration. This is called the prerogatives of the administration. This condition is applied in the Egyptian legal system and our Saudi Arabia legal system, but not in French legal system, because the French legal system applied only to the first two conditions. This is because the administration always is working for the public interest. We all know that on 11 March 2020, the World Health Organization upgraded the COVID-19 outbreak from public health emergency of international concern to a pandemic as a result of its gravity. Different industries have been hard hit by the aggressive measures imposed by the authorities worldwide, and working from home is not an option for labor except for certain activities. These measures have disrupted many businesses' operations and different contractual relationships. Therefore, many questions arose about the impact of the epidemic on contracts and the legal agreements, and many voices calling for the necessity of declaring this epidemic as a force majeure. Therefore, it became necessary to clarify the epidemic on the execution of the international administrative contract. It is considered a force majeure and the rights and obligation of each party during the period of the pandemic. In fact, most civil jurisdictions apply a different regime and rules to public contracts. Public contracts that the contracts, as I mentioned, entered into with the state or public agents, and private contracts, which conclude between private parties. Moreover, disputes are resolved by administrative courts for public contracts and the civil or commercial courts for private contracts. Regarding the coronavirus and the force majeure, we can find in common law countries that force majeure exists only as a contractual concept. That leads to the fact that unless the contract expressly states otherwise, force majeure in such jurisdictions may entitle the contractor to an extension of time or to termination without fault, but not to compensation for extra costs and losses. We all know that this is probably not the ideal outcome for contractors facing substantial additional charges as a result of the pandemic. Therefore, another legal concept generally referred to as hardship has been created. We will discuss that in detail. By contrast, most civil law countries acknowledge force majeure as a legal concept, which is generally enshrined in codified law and expanded upon by case law. However, such legal concepts will differ from one jurisdiction to another and also evolve over time within the same jurisdiction. Now, it became more complicated, so that we have to clarify the situation of each country in dealing with the pandemic of COVID-19 Additionally, the rights and obligation of each party in case according to the following. We will focus on two main aspects. Firstly, assessing how the pandemic may qualify as a force majeure in both common and civil law countries and its consequences. The analysis includes France, Italy, India, Germany, Spain, England, Netherlands, Sweden, Egypt, and international law. Additionally, we will answer numerous questions that aroused the international legal field during the period of pandemic for clarifying the rights of the contracting parties. Regarding the first party, or the first part, how the pandemic may qualify as a force majeure in both common and civil law countries, and the consequences of that. Here we will explain how international legislation in many countries dealt with this matter as follows. First country, France. The force majeure in France, according to Article 1218, French Civil Code stipulated that there is a force majeure in matters relating to a contract when an event beyond the control of the debtor that was not foreseeable at the time of the contract and whose effect couldn't be avoided by appropriate means prevents the debtor from performing his obligations. French courts have established that to consider an event as a force majeure, it had to be, there is three conditions here adopted by the French courts. First condition, the event should be unforeseeable. That means the event couldn't have been reasonably foreseen at the time of the contract, and the French courts expected an exceptional contractor to foresee most events that could negatively impact the works. Second condition is that the event should be irresistible. It had to be beyond the control of the contractual parties and couldn't be prevented or avoided by adequate steps. And the final condition is that the event should be external. That means the occurrence of the event didn't have any connection with the parts. From the other side, and regarding the burden of proof, the party seeking to invoke force majeure, typically the party who stopped performing the contract duties or obligations, must prove that these conditions are met. Such party will typically need to show a causal link between the force majeure event and the failure to perform contractual obligations. We should notice that French jurisprudence in their earlier decisions has been reluctant to admit the epidemics such as Ebola, SARS, or H1N1 flu could qualify as a force majeure. This COVID-19 pandemic is, however, unprecedented not only as a deadly global outbreak, but also in consideration of the government's radical measures taken as an attempt to control its spread. However, the Court of Appeal of Colmar decision rendered on March 12, 2020 has already ruled that COVID-19 is a force majeure event. We might assume that this case law was the first one issued in France on this issue. Actually, the application of force majeure will always be assessed by the French judge to determine whether the coronavirus pandemic constitutes a force majeure event or not, on the basis of the facts of each case, and in particular with regard to the possibility of implementing appropriate measures to prevent or avoid adverse effects on the performance of the contract. Additionally, and regarding the hardship, this is a new conception which created by the legislator and the jurisprudence of the Council of State. The legal term of hardship, which is called in French language that la théorie de l'imprévision en France, This concept has derived from the jurisprudence of the Council of State. In addition, the French Civil Code, which provided that if a change of circumstances unforeseeable at the time of the contract render performance excessively onerous for a party who has not agreed to bear the risk. Therefore, such party is entitled to ask the other party for a renegotiation of the contract. It will, however, continue to perform its obligation during the renegotiation period. Basically, that means if the occurrence of an unforeseeable event makes it very difficult or substantially more hardship, more onerous for the contract to continue the performance of its obligations as agreed in the contract, hardship may be invoked by the contractor of a public contract. Additionally, the contractor is entitled to seek compensation and or to ask for renegotiation of onerous terms of the contract in the event the economic balance of the contract is likely to be disrupted by some 30% or more. What is the rationale behind that? The rationale behind that such an administrative legal term is to ensure the continuity of public service as a priority over and above the security of contracts. It is noted would open a new path to contractors who would rather continue performance of their contracts at economically acceptable conditions rather than rely on force majeure and the limited relief of an extension of time or an early termination without compensation. Therefore, on 25 March 2020, the French government adopted Ordinance number 306 on extension of time limits and adoption of legal procedure during the period of public health emergency. Now, we will talk about another country, which is India. In India, the concept of force majeure finds its genesis under the Indian Contract Act 1872, when it is relatable to an express or implied clause in a contract. It is governed by Chapter 3 dealing with contingent contracts, and more particularly Section 32 thereof. A force majeure event which occurs or that means outside the contract, it is dealt with by a rule of positive law under Section 56 of the Act. Section 56 of the Act deal with the agreement to do an impossible act or to do acts which afterwards become impossible or unlawful. The approach of the courts has been also like the court of the High Court of Bombay or the High Court of Delhi has been to examine the issue based on the facts of each case, and the relief has been granted to parties accordingly. Regarding the Italy and the situation in the legislation there, Italy was one of the first and the most affected European countries which faced the pandemic, which leads the government to adopt drastic measures such as the closure of non-core economic activities and the restriction of the free movement of people and goods. In front of the obvious effect of this measure on the economy, the government provided an initial response with Decree Law number 9 of 2 March 2020, stipulated that the terms for contractual obligation were suspended from February 22 to March 31 of this year for those who work in the cities affected by the pandemic. Additionally, the Italian government intervened again with Decree Law number 18 of March 17, 2020, introducing the new paragraph providing that compliance with the containment measures referred to in this decree is always considered for the purposes of execution, pursuant to and for the effects of the article of the Italian Civil Code of the debtor liability, also with regard to the application of any forfeiture or penalties connected with delayed or failed performance. This measure didn't consider the pandemic as a force majeure explicitly, of course, but rather they applied procedures that guarantee the rights of the damaged party. Now, regarding the Germany, in order to face the COVID-19 pandemic, Germany has passed the law on mitigating the consequences of the COVID-19 pandemic in civil, bankruptcy, and the criminal procedure law. With regards to contract law, the legislature provides a right to refuse performance. This is a new rule or a new rule which created by the legislator called the right to refuse performance for consumers and micro business, a maximum of 2 million euro as annual turnover. Until June 30, 2020, this applied to essential long-term contracts which have been concluded before March 8, 2020. This includes particularly contracts for the supply of electricity and gas or telecommunication services and for water supply and disposal. An extension option up to a maximum of 30 September 2020 has already been created in the law. According to this article, contractors who are unable to fulfill their contractual obligation due to the COVID-19 pandemic are granted the right to temporarily refuse or cease their performance without being subject to legal responsibility. This also excludes liability for damage caused by delay and an obligation to pay interest. However, the exercise of the right to refuse performance is excluded if the contractual creditor can't be reasonably expected to exercise it. In this case, the micro-entrepreneur has the option of being released from the contract. Regarding Spain, the additional provision force of the Royal Decree, which issued on 14 March 2020, was the procedure issued by the Spain government to handle the COVID-19 pandemic effect. It declared the state of alarm, stipulating that the suspension of the state of limitations and the expiration of any actions and right during the validity of the state of alarm. The jurisprudence decided that this lack of legal support doesn't imply that the pandemic situation and the state of alarm don't affect the ordinary contractual obligations. And to solve the arising issues, reference is to be made to the following Spanish law principle: pacta sunt servanda. That means the obligation to comply with what has been agreed in the contract, which must be balanced with the fortuitous event and the force majeure principles. The Supreme Court in Spain indicate that in order to apply the force majeure, it must be a matter of circumstances, totally unpredictable at the time of contracting and that by themselves prevent the provision. On the other hand, the Supreme Court also required good faith in the contractual field. Regarding the situation in England, we find that situation in England, like the USA or America, English statute don't cover this issue, which means that the force majeure is a creature of a contract and not of a general common law out. The general rule applicable here is that where a party doesn't perform its obligations under a contract, this would give rise to liability towards the other party. However, if a contract doesn't include a force majeure clause, the contract could potentially still be terminated on the grounds of frustration, which means when something occurs after the formation of the contract which renders it physically or commercially impossible to fulfill the contract, this will be a case of frustration. If a contract has been frustrated, it is automatically discharged and the parties are excused from their future obligations. Otherwise, taking into consideration the unprecedented nature of the COVID-19 outbreak and or the action of the government around the world in response, most of jurists expected that COVID-19 would constitute a force majeure event under force majeure clauses which are mentioned above, which will lead to excuse the contractor from its obligations and liability under the contract without any damage being payable, extension of time, suspension of time, or termination in case of non-performance. Now, and regarding the Netherlands, we found that in the Dutch legal system, there are no specific laws that regulate the fate of contractual obligations that are not enforceable due to the effects of the coronavirus emergency, and no provision to consider it as a force majeure. However, the Dutch government has taken measures to help business that are affected by this crisis. For example, the government will award a compensation of €4,000 to business sectors that have been hit hardest by the mandatory closing until 6 April. This is a measure taken to handle with the effects of the COVID-19 in Netherlands. Now, and regarding the Sweden legal system, in Sweden, force majeure is not regulated in statutory law, and there is a case of legislative because the Swedish parliament, contrary to some other European countries, hasn't issued any specific laws or regulations regarding contractual obligations during the period of pandemic. We can say that if a contractual parties have agreed on a force majeure clause, this clause will determine whether or not a specific situation can be classified as a force majeure. Additionally, in order to determine if a party is relieved from responsibility for not being able to perform according to contract with reference to force majeure, it is necessary to analyze the agreed force majeure clause and the specific circumstances of the particular case. Now, and regarding the situation in Egypt, my country, as a rule, for reasons of force majeure or the public interest, the public administration has the right to declare the suspension of the contract or even revoke the contract. This is possible for the administration in the Egyptian legislation for reasons of public interest. This is because of acts of God, force majeure, or the public interest. The suspension or the termination of the administration contract here is unilateral. That means from one side of the administration. The government declared that the case of national emergency in Egypt due to the COVID-19 pandemic. In addition, the Egyptian legislature per Article 147 of the Egyptian Civil Code provided that when, however, as a result of exceptional and unpredictable events of general character, the performance of contractual obligations without becoming impossible becomes excessively onerous in such way as to threaten the debtor with exorbitant loss. The judge may, according to the circumstances and after taking into consideration the interests of both parties, the judge can reduce to reasonable limits the obligations the obligation that has become excessive. Moreover, the Supreme Administrative Court classified the coronavirus as a force majeure in March 2020. Finally, and regarding the international law and how the international law organizes the effects of pandemic during the period of pandemic, this effect is that applied on the administrative contracts or public international contracts, who found that the international law, it is a fact that there is no European regulations or international conventions governing such issue. However, support may be provided by the Vienna Convention of 1980 and by the unilateral principles. According to Article 79 of the Vienna Convention on Contracts for the International Sale of Goods, we found that failure to perform a contractual obligation which has caused by an impediment like force majeure, beyond the debtor control and not foreseeable at the time the contract was signed, is not a source of the contractor liability. More generally, the principle of the international trade unilateral provide that if an unforeseeable and uncontrollable event threats the fundamental balance of the contract, either by reducing the value of the performance or increasing its costs, the disadvantaged party is entitled to ask the other party to renegotiate the terms of the contract, and in the alternative, to ask for the termination of the contract. Now, move on the second section, which include numerous questions that aroused the international legal field during the period of pandemic for clarifying the rights and obligation of the contracting parties. We found that regarding the first question, can a contractor ask for a contract suspension due to the COVID-19 pandemic? The answer will be yes. The contractor can request the suspension of a contract due to a force majeure or fortuitous event. However, it's up to the public administration to decide if the request is granted or not according to the reasons of public interest and the surrounding circumstances of each case. Second question is, in which phase the contract can be suspended due to the COVID-19 pandemic? The suspension of the contract can be declared once the contract is effective and during its execution. Third question is that, what is the maximum term in which the execution of the contract can be suspended? We found that in most of the legislations around the world, like the Egyptian legislation, French legislation, Emirates legislation, we found that 6 months is the maximum term for the suspension of the execution of the contract, which can be extended for another equal term. What are the required procedures to declare the suspension of the contract? Regarding the required procedure to declare the suspension of the contract, we found that the suspension should be notified by writing. The suspension should be notified by writing and indicating the following: the part of the contract that has already been executed until the moment and its current status. Who is responsible for safeguarding the part that has already been executed? Measures that will be taken to guarantee the financial balance of the contract. the date in which the contract execution will restart, which should also be notified in writing before the date in which the suspension comes to an end. Additionally, what are the effects of contract suspension with respect to the rights and obligations of the party? We found that the suspension of the contract implies the suspension of all obligations and rights of the parties, and therefore entails the suspension of the contract's term as well. However, it is possible that the term for the execution of the contract is suspended and the contract's obligation remain according to different legislations. Another question: what happens if the contractor doesn't receive any notification of the suspension of the contract? In this situation, the contractor should continue executing the contract under the terms and conditions previously agreed upon. Is the contractor entitled to compensation in case of contract suspension due to the COVID-19 pandemic? In case of contract suspension, the administration should recognize the following economic compensation to the contractor. From one side, compensation for the part of the contract that has already been executed, and from the other side, damage compensation due to the contract suspension. Another question: is the contractor entitled to claim for renegotiation of lost profits caused by the contract suspension due to the COVID-19 pandemic? We found that since contract suspension due to COVID-19 originates from force majeure or fortuitous event and not in a unilateral action of the public administration, on principle, there is no right of the contractor to claim lost profits. However, each case should be analyzed in the light of the surrounding circumstances which appreciated by the judge of the contract. Final question is that what happens if the contractor doesn't restart contract implementation, execution on the agreed upon date? If this happens and the contractor doesn't restart contract implementation or execution on the agreed upon date, the procedure of termination of the contract should be adopted by the administration unless the public interest reasons require immediate execution of the contract. Finally, it is expected that with the rapid spread of COVID-19 and the expansion and escalation of government measures taken to compete and contain the outbreak, we are likely to see more cases of parties declaring force majeure. However, we recommended that affected companies should review the force majeure provisions in their contracts carefully and consider the implication if such force majeure provisions are to be invoked. Companies also consider drafting their force majeure clauses more broadly in the future to clearly include epidemics and public health emergencies without the need to rely on a force majeure certification. Thank you very much for giving me a chance to participate with you in this summer school event. Thank you very much.
Thank you so much, sir. Am I visible? Audible? Can you hear me?
Yes. Yes, I hear
So, yeah, thank you so much, sir, for this detailed presentation. And now we quickly move on to the question answer round. If somebody has any question for sir, kindly please ask.
Good afternoon, sir. I have a question myself, Maya. Sir, I think I'm audible, right?
Yes, Mani.
Yeah. So the contractual obligations have eventually come under the microscopic view of the international law during the present times of the pandemic. So my question is twofold. Firstly, how should or the people who are contracting in the present time should draft their force majeure clause? Firstly, secondly, can you please throw some light on the doctrine of frustration? Why should that not be
Excuse me.
applicable, and why is force majeure applicable?
Excuse me. Can you
Yes, sir.
please? Could you please repeat your question?
Mani, I think the
Sure,
line is
sir.
not
Am I
clear. Why
audible
don't you
now?
type it? Yeah, yeah, but the line is not clear. So why don't you just type it and sir can read it?
Yes, I hear you. Can you repeat your question, please, or write it?
Yes, sir, she's writing the
Shall
question.
I type or shall I just speak out the question?
I think it is
Okay,
clear now.
okay, you
You
can
can
type.
ask.
Yeah,
Whatever
it's a long
suits you.
question. If it's audible, can I just speak out my
Yeah, yeah,
question?
yeah, yeah. You can
Yeah.
ask now.
So, sir, my question was, since the contractual obligation in the present time has come under the microscopic view of the international law, I have basically twofold question in regard to this. First, how should the companies draft their force majeure clause? Secondly, can you please just throw some light on doctrine of frustration? Why is it not applicable here? That's all. Thank you.
Okay, can you please write your question and I will read it
Yeah, sure,
to
I'll
be
do so.
clear because I can't hear you clearly.
There is some problem in the line. Whoever has a question, please
Yes,
type it in the box.
yes, it will be better to write it in the box.
Sir, you received the question?
Wait a moment. Contractual obligations. No, 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 international is to hold compliment. Yes, I received your question. I'd like to inform you that the companies should insert a clear clause in their contracts which organize the question of the force majeure. That means that most of companies let the question, the emergency question to the codified laws, and this is create a problem. For example, at our situation at the time of the pandemic, we find that most of companies contractors invoked the legislations, and the legislation sometimes didn't mention the case of force majeure for these pandemics. You understand me? That means that the companies should insert in their contracts from the beginning a clause or a condition which organize the case of the pandemic, and they determine in the contracts which cases that can be considered as a force majeure. For example, we will consider as a force majeure those cases. Firstly, the pandemic. Secondly, the acts of the God. Thirdly, earthquake and others. This will help in case of conflict between parts or in case of the difficulty to execute the obligations. We found that refer to contract or back to contract clauses, we find a condition or a clause which mentioned or organize the situation or the case of the force majeure and determine its cases. Is that clear? Is that
Manya?
clear?
Yes, sir, that's clear. I have added 2 more questions if you can answer those. It's in the chat box.
Okay, regarding the other questions, regarding the frustration, the difference between the frustration and the force majeure is the case of or the condition of the act, the required condition to consider an act or an event as a force majeure or an act of frustration. For consider an act as a force majeure, it is clear there is 3 conditions which are required. It should be unpredictable out of the parties' action and unforeseeable also. Regarding the frustration, the jurisprudence or the doctrine adopted the principle of frustration because the condition of force majeure are not existed in all or in most of cases. Therefore, the doctrine applied the frustration rule or created the principle of frustration, which based on two main conditions, which are that the execution of the contract will be very hard or will be very costable. That means that the party or the disadvantaged party can't execute his contract without bear high losses. This is this is the first condition, and the other condition is that this act wasn't unforeseeable or can't be predictable at the time of the conclusion of the contract. This rule of frustration is created to face the cases of non-execution or the difficulty of the execution of the contract. Is that clear?
Thank you so much, sir.
Thank you so
Okay.
much, sir.
Okay, you are welcome.
Yeah, thank you, sir. The network is very poor, I think, and but thank you
Okay.
for the on the behalf of the all the participants and ISLR. Thank you for taking time out for us and enlightening us with this
Thank you.
detailed presentation. And may you have a good day and all the best to all the participants also. Thank you.
Thank you very much for participation, for the invitation, and for all the colleagues and the speakers and participants in the summer school occasion this year. It's an honor to be with you. Thank you very much and have a great day.